This September, the U.S. military carried out lethal kinetic strikes on 3 boats that were traveling in international waters. Some of the boats were accused of having members of designated terrorist organizations and large quantities of cocaine and fentanyl on board. The strikes killed 17 people. President Trump argued that these actions were a necessary escalation to stem the flow of drugs into the United States, though the administration did not offer an explanation as to how the cargo was assessed or how crew affiliation was determined. The strikes prompted international condemnation, and bipartisan voices in Congress have raised concerns about their legality. According to researchers Kendra McSweeney and Matt Coleman, enforcement in international waters is nothing new. The U.S. routinely intercepts alleged drug boats outside its jurisdiction and detains the crew for criminal prosecution in the U.S. under the Maritime Drug Law Enforcement Act, or MDLEA. So if what happened in September was a dramatic departure from the U.S.'s usual enforcement practices, what does U.S. drug enforcement at sea look like? Are the people we pick up key players in cartels, or are they just little fish? And how does their criminal justice journey compare to drug traffickers apprehended on U.S. soil? From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we're diving into the world of maritime drug enforcement and learning about boat defendants ensnared by the U.S. federal justice system. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. One of the great things about our work at the Drug Enforcement and Policy Center is our ability to interact with scholars across all kinds of fields.
Absolutely. Our guests, I believe, are the first 2 geographers we've been lucky enough to have on Drugs on the Docket. We have Dr. Kendra McSweeney, who is a professor and distinguished scholar in the Department of Geography here at The Ohio State University. Her work sits at the intersection of drug policy, environmental change, human geography, in which she has traced the unintended consequences of U.S. interdiction on people and landscapes. We also have Dr. Matt Coleman, who is chair of the Department of Geography here at Ohio State, and like Kendra, has made invaluable contributions to growing scholarship focused on drug policy and enforcement in the United States, and talks about being a legal geographer, which is fascinating to me because I kind of get the legal part, but I don't always fully understand the geography part. But what makes me so grateful to have them as guests on the podcast is the way in which I had the good fortune to work with them on parts of the project we're going to be discussing, and to see various aspects of their work, their data collection, their data analysis, not just through the lens of geographers, different background, different discipline, but realizing how incredibly opaque the federal legal system is. And yet that very opaqueness doesn't necessarily mean I understand it better as a lawyer. So with that, thank you, Kendra and Matt, for joining us.
Great to be here.
Thank you so much.
Doug, thanks for that context. What was it about drug policy in your field of geography that was so compelling that you started looking at populations impacted by moving drugs or being couriers for drugs, like the drug trade, if you will? What was it about this topic that drew you to it?
Good question. I wasn't certainly not expecting to study drugs or become interested in drug policy, but I had worked in a community in eastern Honduras, an indigenous community, really remote in the rainforest since the mid-90s. And about 15 years ago, I went back to what had been a beautiful place within a biosphere reserve and saw that it had just been devastated.
Like environmentally devastated?
Huge ecological impact, huge social impact. So dispossession, indigenous communities were losing their lands, ecological devastation. And people said it's because drugs are being moved through here now. I didn't understand why the transshipment of drugs through a space would have such a huge impact. So that took me into the world of what happens when a drug is made illegal. And when a drug is made illegal, it has to move in ways that are very different from legal commodities. And that ends up having huge impacts on very remote places through which it's smuggled.
Well, I got interested in this stuff thanks to Kendra. My background is working on immigration enforcement and the delegation of federal immigration authority to sheriffs and police. And so as part of that, I became really familiar with search and seizure practice in the United States, with Fourth Amendment law, the sort of intersection of criminal law and immigration law, what's typically known as crimmigration. And Kendra came to me and said, "Hey, did you know that the Coast Guard are basically making these seizures and searches at sea for these drug couriers? And does this interest you?" And when she initially said that to me, I was like, "I got too much going on. I can't focus on this stuff." But after repeated attempts to enroll me, I sat down and looked at the material and quickly became compelled in it. And now this has become like a really core part of my research identity.
How do you connect with the resources that you need to better understand the subject matter from like a legal standpoint as opposed to a geography standpoint?
Well, one of the things I reached out to Matt for was like, you're a legal geographer. Tell me more about the legality of this. But then I happened to sit next to Doug at a event, and I was like, there's some things we don't understand about what we're finding. And it was Doug who said, "Well, what kind of sentences are they getting?" And I was like, we haven't really been looking at that. So in answer to your question, I'd say serendipity.
So were you familiar with like the First Step Act and just the evolution of drug policy in the US before you embarked on this research?
Well, I was very familiar with U.S. drug policy as it is implemented overseas and as it impacts Latin America, particularly the counter-narcotic realm, the highly militarized form that it takes at sea, but also on land in Latin America, how the DEA works in Central America, for example, how the State Department works there. But I had not really focused too much. In fact, I knew very little about drug laws in the United States.
Before we dive into federal sentencing for what Matt and Kendra's research describes as an unusual subcategory of non-citizen drug offenders, and that's like a direct quote from the article, Doug, I would love for you to recap how federal sentencing works in general.
In short form, there is a bunch of law now that controls federal sentencing. There was a time when judges had complete discretion to pick any sentence within broad ranges, but now there are both advisory sentencing guidelines that judges must at least pay some respect to, and then there's statutory terms that in the context of drug sentencing is built around what are colloquially called mandatory minimums. There are some statutory provisions that say if you meet certain criteria, a judge is allowed to sentence below that minimum. But generally speaking, there are these mandatory minimums. And one of the things that legal analysts and commentators have discussed at length is the perniciousness of the fact that those minimums hinge entirely on drug quantities. So if a particular defendant, whatever their relationship to that drug quantity, maybe they're getting paid only a few $100s in order to move a truck, how much drugs is in that truck determines whether a 5-year mandatory minimum or a 10-year mandatory minimum is going to apply. And that's seen as a very poor proxy. In fact, one of my very first articles was highlighting the fact early on in the guideline mandatory minimum drug sentencing system that very low-level offenders were getting stuck with high mandatory minimums, whereas higher-level offenders, among other things, had information to trade with prosecutors in order to get below those mandatory minimums. And then there's a whole intricate system built on top of that that sometimes allows a judge to consider some of these more, I would call, relevant factors of culpability. But at the end of the day, drug quantity ends up being this kind of determining what kind of sentence a particular drug defendant will be facing, and many times completely scripting what sentence they'll actually get.
So we have one way of trafficking drugs, which is over land, by truck, by person, by car, or on foot. And then we have a different kind of way of getting drugs across borders, and that is on a boat. So what are boat defendants? When did you start to uncover that there was maybe a larger story here?
I had been working with a team of other scholars to understand the impact of drug trafficking through Central America on indigenous people and forests and protected areas. And what we realized was that drugs were landing in very remote areas, in part because Coast Guard counter-narcotic activities out on the water, way off of land in places we couldn't see, were really shaping where the drugs were being landed and why traffickers were concentrating their landing zones in particular areas. And when I talk about traffickers, what I mean here are people who are usually fishermen from fishing communities on the coasts of Central America, South America, Caribbean islands, and they are paid very minimal sums to get on a boat, usually loaded with about 700 to 800 kilos of high purity cocaine. And they get on those boats somewhere in what the counter narcotic community calls a source zone. So one of the places that is exporting cocaine. And all of the cases that we have dealt with are cases where it is cocaine produced in Colombia that is moving out, sometimes through Ecuador, sometimes through the Pacific coast of Colombia, sometimes through the Caribbean coast of Colombia. So these boats are loaded with drugs, and then a crew of 3 to 4 guys basically spends days at sea moving those drugs in 75% of the cases we looked at through the Eastern Pacific, which is a pretty unforgiving ocean, towards the Pacific coasts of Central America and Mexico. And those are their destinations. And when they get picked up by the Coast Guard and eventually prosecuted in the United States, they're called boat defendants because they were picked up at sea, usually in international waters, by the Coast Guard on a boat. So boat defendants. So one of the reasons that the U.S. Coast Guard is interested in intercepting these boats, what they say as very deep in the transit zone, is so that they can get the bulk quantities of wholesale drugs before they arrive on land and then get divided up into smaller amounts that are obviously harder to track. Some people call these guys on the boats boat mules because they have no personal interest in the drugs. They are the equivalent of a guy driving your Amazon truck and delivering the packages.
So Matt, what happens when they get picked up by the Coast Guard? How are they then processed through the U.S. court system? Like, what government actors are they interacting with typically?
It's quite an incredible journey. There are several routes through which drugs are transited through this zone, the Eastern Pacific, the Western Caribbean, and sort of through the center middle of the Caribbean. And the boats on which the drugs are ferried are 18 to 22-foot vessels called pangas. And it's really quite incredible if you think about loading one of those up with, let's say, it's 600 to 700 kilograms of cocaine and then fuel to make the journey, which can be just as much in terms of weight. And then maybe 2 mariners, maybe 3 mariners. And you put these guys out to sea many, many hundreds of miles from the nearest shoreline. It's a pretty rigorous journey. One of the things that attracted me to the project was indeed this idea of the ocean as not a frictionless space, but a really challenging logistical space that's very difficult to move narcotics across this space. It's very difficult to intercept those boats across this space. I'll add that it's an enormously expensive undertaking. This interdiction regime costs billions and billions of dollars. And effectively what it is doing is picking up and imprisoning the people who are literally at the very lowest levels of, the drug economy.
Right. The Coast Guard's interdiction budget, I think, was $5 billion. And then I think the latest data I saw was it cost $36,000 to incarcerate an offender in a federal facility per year. And if you have to do that over 10 years and you're doing it with hundreds of foreign nationals that could conceivably be prosecuted in their home countries where they're closer to their family without, adding to the human suffering that they experience, that would seem better. It's pretty spectacular what an interdiction looks like. What we know of them is wholly scripted by the law enforcement authorities that do it. And that law enforcement authority is the Coast Guard. So the Coast Guard is both a part of the military, but it is also a law enforcement agency under the Department of Homeland Security. So interdiction happens. The men are detained on a Coast Guard cutter. They are zip tied and typically chained on board the Coast Guard cutter that then needs to move them from wherever they were interdicted. And then they're handed off by the Coast Guard ultimately to the U.S. Marshal Service that processes them into the U.S. So when they arrive on land, they get processed, they get given an A number, they are paroled into the United States for the purposes of their own prosecution.
So I want to pause there because this goes from an incredible human story to an incredible legal story. As you all were describing it, and I think I've got this right, these folks haven't ever set foot in the United States. Maybe they're not even planning to set foot in the United States. Arguably, the U.S. authorities think it's valuable to interdict this huge quantity of drugs at this stage. But then they could presumably, take the drugs and tell the guy, go home, or some variation on that theme. Now, I'm inclined to then guess the federal authorities just assume that this fisherman they've picked up in this boat is doing, dozens, hundreds of these trips. That's often how we think about, though it's not always accurate, the mules on land. This is somebody who's making $500 for this run, and then they're going to complete that, and then next week they're going to make $500 for the next run, and on and on and on and on. And so the justification to prosecute is to both deter other people, but then also keep this person from being a constant source of drug trafficking. Is that the reality of these defendants? Are these folks who the government knows are, going to be involved in a lifetime of, lucrative transportation of drugs, or is the story even more depressing?
There are millions of people who are fisher people in Central and South America who could be enrolled into the role of moving these drugs. And most of the people that are picked up are first-time offenders. Their average age is 40, and they are paid by the trafficking organizations because they're fishermen, because they're not afraid to be in an open boat at sea in a hurricane. It's kind of terrifying what they endure. And really, the only people willing to do this stuff are people with high seas fishing experience, and there are a lot of them. So the idea that somehow picking these guys up is any kind of deterrence is laughable, partly because I don't think the news that they were picked up or being incarcerated necessarily even reaches their home communities in any meaningful sort of way.
This is not a situation, as is common for other drug trafficking within the United States. Oh, this person's trafficking in Florida, maybe picking up drugs at the coast, but then moving it through the state. And then, of course, we'll pick them up and prosecute them in Florida, or they're doing it in Ohio, where we are, or wherever else it is. It makes sense if they're actively transporting drugs within a particular community that community wants to arrest and then prosecute that person there. But here they're on the high seas, have never set foot in the United States. So how do we even figure out when they get paroled, as you say? That's the fancy term for brought into the United States jurisdiction for purposes of prosecution. When they're paroled into the United States, who decides where that is and how that functions?
That's something of a black box. It is a closely guarded secret exactly why particular boat defendants are brought to particular jurisdictions. We certainly know that most of them go to the Middle District of Florida, more than half. And we know that Tampa is certainly an expert court for prosecuting these guys. But one thing I will say is the logic that is given by the Coast Guard for why they do what they do is that, one, and you'll find this deep within various court documents and elsewhere, the guys aren't remanded to partner nations. Like, say they pick up a Guatemalan at sea. The guy is not sent to Guatemala because, frankly, the U.S. government doesn't trust the Guatemalan justice system to prosecute the guy in a way that they would like, favorable outcome. And I think it's also important to remember that one of the biggest justifications for interdicting these drugs and seizing these guys is the narrative that all of these drugs are intended for the United States. Now, 25 years ago, that was probably true. Now, cocaine landing in Mexico, Guatemala, is as likely, if not more likely, to be transshipped to Asia or Europe than it is to cross the U.S.-Mexico border. But that's an inconvenient narrative that you won't hear.
Do we have any sense of what percentage of the boats that are out there doing this kind of transporting get the attention of law enforcement?
Yeah, we know because the U.S. government does a great job in tracking all cocaine movements, and we know that the Coast Guard has never picked up, well, in recent years, has never picked up more than 10%. So 90% of these drug trafficking ventures are arriving and delivering the drugs.
But how many, that 10% that I just caught, how many were just raw numbers? How many per year, roughly speaking? Or
in 2017, for example, there were 4,000 boats that the U.S. verified were carrying cocaine and were northbound out of Colombia. So to give you a rough idea, approximately 8 per day.
And 400 of those were picked up?
That's right.
Got it. Fascinating. And again, I know a little of these details, but every time we go over them, I'm just like, wow, this is quite a story.
I wanted to say that, Doug, previously you had referred to these guys being picked up on the high seas, and that's actually kind of a little bit of a gloss, but they are picked up outside U.S. waters. That's the most important thing.
That's what I was going to ask. How is it that the U.S. Coast Guard is able to pick up these individuals not in U.S. waters?
It's a real puzzle. I mean, one of the things I find most interesting about these cases is the extraterritoriality of U.S. drug law, how it is that U.S. drug law can be applied outside the United States. The extraterritorial application of U.S. criminal law is a pretty rare thing. I mean, the presumption is that U.S. criminal law is going to be territorial in scope. There are examples of the extraterritorial application of U.S. criminal law. They have some sort of contours around them. They've got to be constitutionally vetted. They've got to be written in statute. Like lawmakers have to intend to apply the laws outside the United States. And they must meet the sniff test of international law in one of several ways. So as long as those three legs are on the stool, then criminal law can be exported, but it's really rare. And just to step back a little bit, these seizures are made in international waters, hundreds of miles from the closest U.S. land border, for example. And I think for me, the most fascinating thing here is that when a mariner is taken by the Coast Guard, they are not arrested at the site of interdiction. They are simply detained. In fact, people are only technically arrested when they are passed off to the U.S. Marshal Service and paroled into the United States, giving them an immigrant registration number so we can prosecute them. And so this entire time that they're at sea, they're in this sort of legally ambiguous category of being a detainee and not someone who's technically arrested. When I talk about this to people, I say it's kind of equivalent to being picked up by a police officer in the street, being put in the back seat, being driven around for a couple of weeks while the police officer does groceries, goes and plays some basketball, goes to church, goes to work, occasionally may throw a glass of water in the back seat, and then after 2 weeks decides to bring you into the station and book you and arrest you. In that sort of a context, it would be clearly a constitutional violation. In this particular context, the courts, and specifically the First Circuit and the Fifth Circuit, have said that because the detention occurs at sea, and because the logistics are so crazy for moving people around from a legal standpoint, that delay at sea is okay. So this is a very, very unusual case. I mean, for the most part, when we think about the intersection of policing and immigration in the United States, it's about deporting people who have committed crimes. Here, we are basically bringing people into the country who have committed crimes in order to try them. And again, as Kendra said, with the very important caveat that it's not entirely clear that the drugs were headed to the United States. And absent this paroling into the United States, it's absolutely 100% the case that the mariners would never have set foot in the United States at any point.
That's right. And the authority that the U.S. has is not necessarily over the people, it's an authority over the vessel. So Matt, can you speak to how the U.S. claims jurisdiction over a vessel anywhere at sea?
This is a fascinating question, and there's a bunch of different legal and diplomatic devices that have been put in play which allow the U.S. to claim jurisdiction over a vessel. One of the key ingredients in this legal spaghetti, in this stew of law, is a diplomatic agreement. The U.S. signs diplomatic bilateral agreements with most countries in this so-called transit zone. That means most Central American countries bordering on the Caribbean, and then South American countries on the Eastern Pacific, for example. And these bilateral agreements, these diplomatic agreements, basically cede this power of search and seizure to the United States in a variety of waters. The bilateral agreements are not the same. Each state will tailor the agreement as it sees fit. In the strongest form, essentially, the agreements allow the United States to pull over a huge variety of boats in a huge variety of waters for a huge variety of reasons, and in a way that allows them to take the mariners on board and transit them to the United States for prosecution. Some of the bilateral agreements are more constrained than that, but essentially, this is one of the magic ingredients in this stew. One of the most common ways if the vessel is deemed stateless, if it's not flying a flag of convenience, for example, or if the state of registration is not immediately evident. In that case, the United States sort of exerts its authority.
And I assume, and correct me if I'm wrong, to think this out loud in this context, because it also relates to some of the sentencing stories we'll talk about, but a defendant, presumably poor, fisherman, no resources, going to be appointed a lawyer when here for purposes of prosecution, not exactly in a great position after they've been picked up with kilos and kilos of cocaine to challenge any of this legal spaghetti, as you put it, right? And these particular defendants are in no position to effectively mess with that. And that actually relates to the sentencing story. What happens to their case once they've been brought here and they're fed into our traditional American justice system?
Doug, I don't think I can imagine a more kind of naive or vulnerable legal subject than a unilingual Spanish-speaking fisherman who is all of a sudden finds himself in the Pinellas County Jail in Tampa, and he is thrown in there among other defendants who are probably a pretty tough crowd. So as soon as they are incarcerated in the United States, and of course, they're all held in pretrial detention. None of these guys get bail or anything because they are subject to deportation upon the conclusion of their journey through the justice system. So they're immediately vulnerable, and that we've read a lot of stories where these guys are getting picked on and intimidated, and their families are being threatened just as soon as they land in that detention. I have a lot of respect for the federal public defenders who defend them and really represent the hardship that they face within the jail system to judges. There's a lot of sentencing memos that describe in great detail the ways that these guys suffer in jail and are treated like very little fish at the bottom of the prison pecking order. And they face a lot of violence and threats in jail, but then they get really leaned on by prosecutors, by DEA, HSI, FBI case agents who are just pressuring them for information about the drug trafficking networks that hired them. And often these guys really don't know a lot. Maybe they were coerced into participation in one of these journeys. Some of them describe having a bag put over their head while they were driven to the launch site. And so they don't necessarily have much that they can offer prosecutors, but they get kind of interrogated by case agents as soon as they arrive in the United States. So they've been driving the drugs for, say, 5 days, and they spend an average of 19 days on the deck of a Coast Guard ship in all weather, including hurricanes, and then they get remanded to the United States, and then they get interrogated for all the information, then they get thrown in jail, and then they get given either a public defender or a CGA attorney because they're all indigent. Even their $100 fine is always waived by the judge because they've gotten nothing. They have literally the clothes on their back, and even those are confiscated.
And to explain it, a CGA attorney refers to the system we have in place to appoint lawyers outside of the traditional federal full-time public defender. All of these defendants presumably are told from the get-go, you're facing at least 10 years and probably a lot more by virtue of the quantity of the drugs that were on your boat, notwithstanding that they're, not, no more than the Amazon driver in this context, but that is the reality of how federal law operates, that they are facing a 10-year mandatory minimum absent an ability to either meet a safety valve for sort of low-level offenders or can provide this kind of assistance on finding other drug defendants or other persons involved in the trafficking operations, which, as you mentioned, they may not even know about. And so all of that then leads to an incredible sentencing story that you all covered so well in the Federal Sentencing Reporter article. So why don't we get to that piece of it, talk about the data you gathered and the challenges, I think, that go to that, because that's a really important part of the story, and then what you unearthed in that data to help give us a deeper understanding of how our sentencing system functions for these defendants.
Yeah, well, before I start talking about the process of gathering the data, I want to do a shout out to Ohio State undergraduate students who were paid to do most of this data collection. Kudos to them, because we learned the phrase pacer mining. We ended up mining the public access to court electronic records, a public system that anyone can buy access to that allows you to go into dockets and see what has happened to a defendant. And so we ended up using a very clunky method for identifying these boat cases within the PACER system. We later found out there were a couple of shortcuts, analytical shortcuts we could have used using data from the Sentencing Commission. But in the end, we ended up just pulling a lot of data out of dockets that allowed us to determine who had been picked up, how many people. We feel we have a pretty comprehensive record. So we didn't do a sample. We tried to go for a full census of all of the boat defendants that were brought into the system between fiscal year 2014 and fiscal year 2020. And so we collected as much information as the docket would allow us to gather, from plea agreements, sentencing memoranda, indictments, affidavits attached to indictments or complaints. And those gave us enough information to understand where the guys were picked up, the conditions of the interdiction, where they ended up in the court system, and ultimately how they were sentenced.
Kendra, one of the things you had said earlier is that interdiction happens in the ocean and essentially is not observed. So you and I have pursued a sort of forensic interrogation of interdiction, trying to put together interdiction from an outside standpoint. But it's also the case that the interdictions are hard to scrutinize through the U.S. legal infrastructure. So the U.S. does not publish these cases as a set. So you can't go anywhere or to any sort of government agency and say, like, who's being charged under the Maritime Drug Law Enforcement Act. One of the first things Kendra said to me when we started the project was like, we got to get this full census with like all the cases that have been charged under the MDLEA over the past decade, let's say. And I said to her, well, how are we going to do that? And Kendra devised this method for looking through Pacer, which literally had us reading thousands of pages of documents on Pacer and putting this case together. I think the interesting thing here is that it's a system that in terms of the enforcement apparatus, but also in terms of the litigation, is hard to scrutinize. It's not under a sort of public spotlight. And if you want to look at it, you're going to have to put in the legwork to sort of make it visible.
Right. It's not like the dockets are toggling it as like, well, this is a boat defendant. You know, it'd be great if you could search just one term, but I understand how dockets can be different from jurisdiction to jurisdiction and court to court. And so that definitely sounds like a harrowing journey for the undergrads.
It was.
And here I want to jump in with a particular emphasis on the fact that I think the U.S. Sentencing Commission, which is the specialized agency tasked in the federal system with both developing the sentencing guidelines and then gathering data about how federal sentencing functions in the U.S., it does an incredible amount of very sophisticated data work and analysis that, even though I've been studying their work for decades, literally, I had no idea the boat defendants existed because it's not a category that's set up in their databases for a lot of the reasons we're talking about already. But that's itself, to me, some of the deeper, enduring lessons from this work, both how hard it is. And I just know how Matt and Kendra and their team worked so incredibly hard to define and build out a database to capture these stories, but also the extent to which there's probably hundreds, thousands of other stories that inevitably get lost, but that it's why I so highly recommend the work that Matt and Kendra did in the Federal Sentencing Reporter and commentary on that, because there's layers of the story that are not just about these particular defendants and the way they were treated through our federal system, but how challenging it is to even unearth these stories, let alone gather the data and then be as rigorous as they are in capturing that data. I think that's the other piece that worries me these days, especially. It's not that hard for people with agendas to sort of cherry pick data and tell a story with that data. It's much harder to be as rigorous and thorough as you all were in both gathering the data and then making sure you told the story as richly and as carefully as you have.
So this is a really time-intensive process, gathering this data, and we couldn't have done this without the Mershon Center for International Security Studies. Kendra and I wrote a couple of grants to them, and they funded us, and we were able to pay our undergraduates with thanks to Mershon, and also a grad student who worked for us on a summer cleaning up something we call the detainee database.
So we've talked about how you collected the data, how you funded the collection, and who did that initial kind of audit of the data to create this rich database of boat defendants. So let's get into the data. What did you find?
Well, what I find really interesting about these legal subjects, these boat defendants, is that they are incredibly similarly situated. We found very little variation across the many cases. So we ended up having information on almost 3,000 guys who were picked up at sea. And in terms of the case characteristics, they were all found with powder cocaine on a vessel subject to U.S. jurisdiction. The vast majority were found with over 150 kilos of high purity cocaine. They were all subject to a 10-year mandatory minimum based on that drug quantity. There were no weapons involved in the offense, or very, very rarely. All the cases had at least 2 co-defendants. And then the mariners themselves were very similar. They were majority Spanish speaking. They were all foreign nationals. They were all paroled into the U.S., publicly defended. The vast majority did a plea agreement. 94% of them were sentenced to imprisonment. None of them had a criminal history, and so on and so on. So we're not talking about a highly heterogeneous population of defendants, quite the opposite. And yet, what we found when we started analyzing the sentencing data was that there was remarkable variation in the sentences these guys were receiving. We found that circuits varied dramatically in the average sentences that they were imposing. For example, we found that the 11th Circuit, which includes Florida, was giving boat defendants 10 years on average, whereas the Ninth Circuit, that includes California, was giving them 6 years. And then we found variations within districts. For example, the Middle District of Florida was giving higher sentences than the Southern District of Florida. And then we found dramatic disparity in sentences within districts. So, for example, the courts within the Southern District of Florida, like Key West versus Fort Lauderdale versus Miami, Miami was giving less than 8.5 years, while Key West was giving 12 years. And these are all statistically significant differences. And then, perhaps most dramatically, we found that within a single court, within the Tampa office of the Middle District of Florida, no matter what other variables we held constant, we found significant variation among the sentences that distinct judges imposed. So, for example, the judge that we call Judge Z, on average, gave 7.5 years to boat defendants. And then all else held equal, that was significantly different from Judge X, who gave 11 years. So we're talking about very significant differences among judges within a single court. And that to us was really, really surprising.
I'll add to that we're not just cherry picking. We're not just grabbing the Tampa data to make the point. Tampa is the most important place where the MDLEA cases are tried. 55% of the cases in our data set were tried in the Florida's Middle District. Compare that to, for example, about 17 or 18% of the cases that were tried in the Southern District in Florida and Miami, and about 7 or 8% of the cases that were tried in Puerto Rico. So when Kendra is pointing to this discrepancy among judges in Tampa, she's also pointing to the epicenter, the place where by far the largest volume of MDLEA cases are litigated.
And I'll jump in here and kind of tell two sides of the same story. Here we have this incredible database, and we're seeing these disparate outcomes even in the same courthouse. However, and here's where I'm going to, defend these judges in a kind of a global sense. This is also a database that puts the biggest tension on the difference between the sentencing rules we have for federal drug defendants and a range of other considerations that we debate as to their relevance and importance for sentencing purposes. This is not a group of the worst drug defendants. They are arguably among the most sympathetic personal defendants, and yet they have huge quantities of drugs that the rules say mean they're among the most aggravated defendants. So the cognitive dissonance, you might say, that judges necessarily experience, and then I'll put one last kind of fine point on it. And as judges within local cultures develop reputations, right? We all have heard stories of, the hanging judge versus the lenient judge, and oftentimes those can be overstated, but they do represent certain realities in different judges approaching sentencing different ways. That has a way of catalyzing, because good defense attorneys know to make an extra effort in front of the judges with a history of showing more concern for these sorts of personal factors to really get that in front of the judge. Whereas also good defense attorneys who know Judge X just doesn't want to hear this stuff. They've heard all the sob stories and they are dismissive of the sob stories. In fact, I have an inclination that the more we talk about your terrible background, the harder they're going to go on you. Well, then those factors don't come in front of the judge, and that can end up aggravating the way in which similar cases get presented to judges in different ways and then ultimately lead to different sentencing outcomes. All the more reason this is such a fascinating space to study because of these competing pressures. And then I'll just finalize my comment by highlighting, and across all the other exciting and interesting work that's being done here in the midst of the period that we're collecting data, that Kendrick and Matt are putting this story together, we get the biggest federal sentencing reform in a generation, known as the First Step Act in 2018. And that has two layers to it itself. One is it's changed some of the legal rules with respect to mandatory minimums and guideline ranges and things like that. But it also indisputably echoed through the culture of judging, right? When you see bipartisan members of Congress, then President Trump in his first term, all preaching how valuable it is that we're passing this law that's quite clearly designed to lower drug sentences in a variety of kinds of ways, that's going to echo through these different judges in a bunch of different ways. And that's what the data captures as well. Though, not surprisingly, it echoes through different judges in different ways, because that's just the nature of discretion and the range of forces that come to bear when judges are making these very hard, very personal, very indeterminate type of sentencing judgments.
Doug, I'm really glad you mentioned that, because the transcripts of sentencing hearings really show that for the judges who are really familiar with these cases, there is a real frustration. They are very clear that culpability is not tied to the drug quantity, and yet they have these constraints on them. And I think it's really important to mention that based on the sentencing tables, the average guideline range that these guys should have been getting was 18 years. And so the fact that we found that on average they got half that, they got 9 years, shows that clearly on average judges are understanding that the guideline range is not helpful in these cases. And yet even within that overall sympathetic context, where the story really is that judges are varying quite markedly below those guideline ranges, there's still a lot of disparity. And you're quite right. Some judges have these tried and true ways of sentencing that frankly didn't change too much before or after the First Step Act. And then there are other judges who really seized on the new discretion that they were allowed under the First Step Act to really transform their sentencing practices. Clearly, judges thinking deeply about this stuff, and a lot of them say something to the effect of, I've been sentencing these boat defendants for 15 years, and it's just so frustrating to me.
So the First Step Act went into effect in the time frame of your data set. What's the comparison before and after?
So before the First Step Act, on average, they were getting 9.5 years, which was still many, many years under the average guideline range, given the amount of drugs with which they were found. I want to make that clear, because that isn't necessarily the amount of drugs that was in the indictment. It varied by court. After the First Step Act, the average sentence went down by 1.5 to 8 years. And that relationship was statistically significant. And there may be listeners out there who are going, well, of course you're going to get sentencing disparity because every case is different. Some guys might have a criminal history. Some guys might plead out. Some guys might cooperate more than others and rat out their co-defendants. Some guys are represented by a federal public defender who's really on it. The others might get some washed up CJA attorney. Like, there are so many variables. Of course, there's going to be variation. The thing I want to say to that is, in our analysis, we did a multivariate regression which controlled for all those variables, and we still found that controlling for all those things, the influence of the court in which they were prosecuted and the judge that sentenced them ended up being extremely significant in determining the final sentence that they received and the amount of time they spent in jail.
Kendra, you do say guys a lot. I mean, were there any female defendants?
One female defendant in the final data set of 2,312.
I would imagine that is a reflection of the cultural economic realities of being a fisherman living on a coast in a coastal Spanish-speaking Central American village, right?
That's just the gender division of labor in a fishing community. Yeah.
And so once these sentences are handed down, where do these defendants end up serving this time?
They have served in, I think we tracked down 83 different federal detention facilities around the country to which they were sent. There was a lot of rearrangement during COVID, which coincided with the closure of a lot of privately run prisons under Biden. So these guys have moved around to a lot of different prisons. And there's no one place that concentrates them, unlike the courts in which they're prosecuted, where there is very clear concentration. These guys are pretty randomly distributed across jails from Minnesota to Georgia to Washington State to Ohio. Fort Dix is a relatively popular place.
And to clarify, they'll all get deported once they've finished serving their time. And so, again, in addition to all the hardships that these individuals face as they're brought into the United States and prosecuted, their prison time is harder across a variety of dimensions as well.
Given your research or your looking into these boat defendants, like, what would you urge Congress or the Sentencing Commission to reconsider about how we sentence these particular drug defendants?
I think I would echo what judges are effectively saying with their sentences. What their sentences are clearly signaling is that drug weight is an incredibly poor proxy for culpability or severity of the offense. particularly in these drug courier cases. And this is something that Mona Lynch and Mark Osler really pull out in their response to our article in the Federal Sentencing Reporter. One of the things that Mark Osler pushes for is he says it's really time for the Sentencing Commission and Congress to think seriously about how to tie the severity of the offense not to the quantity of drug with which the person is associated, but rather to their role in the supply chain, the profit that they are earning. The idea of throwing huge 10-year sentences on guys who are making $5,000 for moving hundreds of millions of dollars worth of cocaine is idiotic. What you should be doing is focusing on the people who are at the point of the supply chain to be capturing the largest profits. And frankly, I think that is possible because the U.S. government has very good information on these drug trafficking supply chains and has a very good sense of culpability based on profit. And if that were the criteria used to establish the sentencing guidelines, at least Mark Osler thinks that that is the way forward. The other thing that I would encourage the Sentencing Commission and Congress to think about is the need for more research on judicial discretion. I mean, one of the reasons that Doug got really excited about our data was that we had judge identifiers in the data because we could find them in the dockets. And the Sentencing Commission does not currently release judge identifiers. And so other analysts of sentencing using data from the Sentencing Commission cannot analyze variation among judges. And it's not like there's some conspiracy among judges to impose a diversity of sentences. I think judges themselves are not aware of just how much variation there is in their sentencing. And so if we want to kind of open this black box of judicial discretion, it's going to mean that the Sentencing Commission has got to release data that is disaggregated by judge. Now, they don't necessarily have to name the judge. They don't need to say that was Judge Covington. They can call that Judge Q, as we do in our article. The key is that analysts be able to tie sentencing to particular judges. And I think that would really kind of help everyone, including the judges themselves, to better understand just how crazy things have gotten.
Discretion is obviously not new. The legal system is discretionary from its very beginning to its very end, from the point of law enforcement through to the point of sentencing. But as we talked about earlier in this conversation, discretion is just particularly visible here because the defendant population is so uniform. There are such tight parameters around this group of mariners from a socioeconomic standpoint, from a demographic standpoint, and from a sort of facts of the case, of the criminal case standpoint. And because judges can be identified, because we can scale to the circuits and down to each individual court and to each individual judge, you can really pick up on the differences among what's otherwise a really uniform population of people.
So the disparities in sentencing are just so much more obvious in the similarly situated population.
That's exactly right.
Thank you so much. This was spectacular.
Thanks, Doug. Really appreciate it.
Thank you, Doug.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.